Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. We're still on the topic of agency. So I want to talk to you today about one of the big pitfalls with agency, and that is limited agency. So we all know it's allowed, but it is an exception to state law, and it is an exception to the Code of Ethics. So basically, you're representing two people, a buyer and a seller, on opposing sides of one transaction. Now, you got to go all out for that seller, and you got to go all out for that buyer, but you can't really go all out for either of them when you're representing both of them. So you kind of got to ratchet it back. It's limited. It's limited. You can't fulfill your duty of full disclosure and confidentiality for both parties at the same time. Right? You can't disclose everything you know about the transaction on the buyer side to the seller and still honor confidentiality for the buyer. So that's why it's limited, right? You have a conflict with some of your duties. So right there, it's already a pretty high risk type of a transaction, right? And I've heard this. I heard one lawyer who famously said to a brokerage he was representing, he analyzed all their cases for the year and said, gosh, if you guys just stopped doing limited agency, your legal bill would go down quite a bit. So it is fraught with problems, but can they be avoided? Absolutely. Absolutely. Number one thing is you got to get it in writing from both the buyer and the seller. Both have to have it in writing. And you got to give them the option to not do it, right? And that may mean you refer out a client if they say, I'm not really comfortable with this. That's okay. But make sure that they are on board so they don't come back and say, yeah, my agent roped me into this. The other big pitfall to remember with limited agency is that it includes your broker. So let's say one agent in a brokerage has the seller and another agent brings a buyer and they want to put in an offer. Well, guess what? You have the same broker. So guess what? Both of those clients have the same broker. That is limited agency. Even though the broker is not involved in the transaction daily and isn't really part of the negotiations, it's still considered limited agency because it's a common broker. They both really are clients of the broker. So be careful of that, and remember that you can never have a principal in the transaction. What does that mean? Somebody who has ownership interest or is going to have ownership interest on the buyer side. So if you're representing a buyer and the broker is a partner in a property and they're selling it and they're using another agent to list it within their brokerage, well, guess what? That's going to be an impermissible limited agency transaction because the broker is now a principal in that transaction. So even though the two agents aren't owners, the broker can't represent both of them. Same goes for an agent. You can't ever, even if you have a minority interest, you own 10% of a property and you don't have anything to do with the management of it, but they ask you to list it when they go to sell it, you can't represent any buyers in that transaction because you are a principal in that transaction. Hopefully that makes sense. Just remember, be very careful. Explain how it's limited when you go into the transaction. Explain to both the buyer and the seller, this is what I'm limited in doing. I can't give you all the information. I can't tell you how to price it because I already know the lowest price that the other side is willing to accept, and I can't hurt their bargaining position because I represent them as well. And let them know how it's limited and get them to sign off, and if they're okay with it, then you should be good to go. Extra communication is always helpful in limited agency scenarios, and good paperwork as well. Keep it all clean and be on top of it. But still allowed. I don't know of any pushes to make it illegal in Utah, so I don't foresee it going away in the near future. But do take some extra care with it, and you should be good to go. Remember, as always, this is not specific legal advice. This is legal information only. If you need specific legal advice, please contact your attorney. Thanks for tuning in.